हेलो दोस्तों इससे पहले वाले एमसी मेहता वर्सेस कमल नाथ, उसका लिंक मैं डिस्क्रिप्शन बॉक्स में डाल दूंगा. सो इन दैट वी सॉ दैट ही हैड कंस्ट्रक्टेड अ होटल, अ मोटेल, और उसने नीरी की रिपोर्ट आई थी विच सेड कि द सेट कंस्ट्रक्शंस बंड्स दे वायलेटेड द नेचुरल फ्लो ऑफ रिवर. So accordingly, by application of polluter pays principle, the court asked Kamal Nath and the hotel to pay damages both to the victims and to restore the environmental degradation. And accordingly, there was an issue whether and he was also asked to pay fine for it. So a notice was issued asking them to show cause why fine should not be imposed and to decide the quantum of fine. So this case particularly deals with the determination of fine. So this is again MC Mehta versus Kamal Nath, and this was decided in 2000. So I'll share the link of previous Kamal Nath case here in the description box. Coming to facts of this case. So the respondent argued that we understand that we'll have to pay the cost for as per polluter pays principle to the victims and to restore the environment, and we are okay with that. But regarding fine, there cannot be under Article 32 or under Article 226. In a Writ case, we agree that there is constitutional torts, and the constitutional torts damages compensation can be sought, but fine cannot be sought. And the reason they said was fine is there in criminal jurisprudence. And we know that in criminal jurisprudence, Article 20 follows. So Article 20 says that there cannot be any ex post facto punishment. So basically what does that mean is, at the time of being punished for a criminal offense, as a convict or as an accused, I should know the punishment that will be inflicted to me. So since there is, so if a case is taken up under Article 32 or 226, the court can award compensation as a civil wrong or for a tort, but the court cannot award fine, because fine I should be knowing that अगर मैंने ऐसा किया तो ऐसा होगा. So the fine, when can fine be awarded? So this was an offence under Water Act. So if all the procedure, fair trial of Water Act is followed, after that the court finding me guilty can award fine. I'm okay with that. But this court, which is Supreme Court or High Court, under its writ jurisdiction, cannot award fine to me. However, the appellant, that is MC Mehta, argued that this is just dilatory tactics, and there is nothing wrong with the fine. But the court referred to its polluter pays principle, which it had accepted in the Indian Council for Environmental Legal Action, and then which was also reinforced or affirmed in Vellore Citizen Forum. Vellore Citizens Welfare Forum. And then the court said that we agree that the compensation that is awarded will be to reverse the damage to the ecology and to pay to the victims, but for fine, the respondent argued holds water. And they also referred to, because these cases where the court hears under Article 32 or 226, whatever compensation it awards is for to do complete justice. And then court says that there are already statutes which provide for fine, but they want that there should be a fair trial, there should be a procedure to be followed. And in this case, that procedure was certainly not followed. So the court said that, referred to its case, Supreme Court Bar Association versus Union of India. This was second judge's case. I'm wrong, this was not second judge's case, sorry. So SCBA versus Union of India. So in 1998, the court referred to its powers under Article 142 and said that they are complementary to the powers already conferred by statute. They cannot supplant the statute. So if there is one way in which some particular thing has to hold, and the statute is clear on that, this court under Article 142 cannot say that there is this other way by which I will achieve the same thing. It has to respect the statute. So it cannot go against the express provisions of statute. So that is the understanding. So the court said that fine cannot be imposed. However, the court said that under polluter pays principle, and moreover under constitutional tort, exemplary damages can be imposed, and hence the notice for fine was withdrawn and a fresh notice was issued to show cause why exemplary damages cannot be imposed. And this we'll see in the next case, again titled MC Mehta versus Kamal Nath. तो दोस्तों, एनी क्वेश्चन, एनी कन्फ्यूजन आप कमेंट सेक्शन में ज़रूर बताइए. मिलते हैं अगले वीडियो में फिर MC मेहता वर्सेस कमल नाथ के साथ ही. टिल देन